This is part 2 of this week's material, a brief overview of civil rights. So, like when we talked about civil liberties, civil rights require more than what your textbook gives you in terms of a definition. Your textbook says that civil rights are an American guarantee to equal treatment under the law. And again, that's true, but it's more than that. You want to think of it as an idea of fundamental fairness in every aspect of citizenship. So whether that means something formal like voting or petitioning government, or something a little less formal in terms of government, but important in terms of life, like economic matters, public accommodations, and services. And so when we talk about civil rights, people often confuse the idea of equality and justice. And civil rights do not necessarily mean equality, they mean equal opportunity. So this is a graphic that I really like to use to demonstrate the difference between equality and justice. The idea behind equality is giving someone the exact same thing no matter where they're starting from. Whereas the idea behind justice is giving people what they need to be equal in society. So civil rights are actually a means of justice, not of equality. It's not equal distribution, but rather equal opportunity. And so people often ask why civil rights are still an issue, and that's because there are significant reasons to believe that racism, sexism, and other isms in our society have not left us, as can be seen from these images here, as well as measures of sexism and misogyny, and of course, measures of homophobia, transphobia, and the like. So one argument for civil rights is that doing nothing perpetuates discrimination, that previous inequality is perpetuated by current inequality, and that this is embedded systematically, so you have to dismantle it systematically. There's also a theoretical argument, and that theoretical argument is that our society, going back to Locke, is based up on giving up certain rights, certain freedoms, to ensure civil rights. Civil liberties are, of course, more based in Locke and liberalism, and civil rights find support in civic republicanism because we give up our natural liberties to get these civic rights. And these civic rights find a home in the 14th Amendment, where it says that no state shall deny to any person within its jurisdiction the equal protection of the laws. So when we talk about equal protection, there are two things that have to come into play. One is whether there's a state actor or some sort of legal equivalent in play. So that can be a state actor, it can be something like a public restaurant can be a state actor for purposes of civil rights. If you are open to the public, you're a public actor. And then this idea of scrutiny. And scrutiny is the legal test by which the courts will look to determine whether something has violated someone's civil rights. Normally, in order to prove that its means and its aims are just, the government need only show rational basis, that it has legitimate governmental needs that are, and the means used to achieve those means are rationally related to the ends. So think about driver's license age requirements. There's a reason why we don't give 5-year-olds driver's licenses, right? Because they cannot handle the responsibility. That is something that is a rational basis. It's conceivably legitimate that the government should restrict driver's licenses to people who can handle the responsibility, and the means by which we do it are at least rationally related to the ends. But when something involves a classification like race, ethnicity, color, religion, we move over to the other end, which is strict scrutiny. So when government makes distinctions based on race, in particular, but others as well, like color and ethnicity, or national origin, the government must show that its interest is compelling and that the means it uses are necessary to achieve those ends. And they've narrowly tailored them. They're not going overboard. So things that fall into this category are pretty rare. And so we don't find many of them being sustained. Most of them are shot down. If a government actor or a public actor makes discriminating rules based on race, for example. They usually do not stand. In the middle, we find gender. Gender, sometimes sexual orientation, does not receive strict scrutiny, but it's not a rational basis. So instead of compelling, you have genuine and important, and substantially related to the ends. And so often gender-related reproductive health issues and the like would fall under this. The idea to remember here is not these tests. If you're interested in this, and if you're interested in going to law school, we teach classes here at the university that can kind of introduce you to this in a more in-depth way. But the idea is to know that strict scrutiny comes into play when certain classifications are at issue, that intermediate scrutiny comes into play when gender or sexual orientation, but particularly gender, come into play, and then everything else is rational basis. That brings us to the supplemental reading this week, which is John Rawls. And John Rawls wrote about justice as fairness. And he said that there is a way to conceive of how justice should be carried out. That the principles of justice must be conceived of in a certain state. That we must put ourselves behind what he calls a veil of ignorance. And a veil of ignorance, or the original position, allows us to disassociate our logical side with our personal situation in life. So we might not know what race we are, what age, socioeconomic status, etc. And by doing that, we are likely to treat everybody fairly, one, but two, also provide certain advantages to the disadvantaged, because we might end up being one of the disadvantaged. There are two main principles of justice. Once you have put yourself behind the veil of ignorance, to distribute rights, there are two things. One is equality, that you should distribute evenly whenever possible. And then two is fairness, that when you have a difference in what is distributed, people who are disadvantaged should receive more. So in our legal system, which really does follow a lot of what Rawls was talking about here, this comes into play with equal treatment under the law, that the needs of many do not outweigh the needs of the few, but that differences must be narrowly tailored. Some differences between people are inevitable. No society exists where everybody is alike. But if there are going to be differences in what government provides, those differences should be limited and should serve to benefit the least advantaged members of society. One of the key areas for civil rights is voting. And as we've mentioned before, the 15th Amendment, the 19th Amendment, and the Voting Rights Act are all elements of the civil rights movement towards equal voting opportunity. And in the 1970s and beyond, we see a movement to broaden the scope up until 2013, when we have the Shelby County versus Holder case, which rolls back some of the provisions of the Voting Rights Act. In education, we see school segregation, affirmative action, Title IX for gender equality, and the Americans with Disabilities Act and the Rehabilitation Act for people with disabilities as elements of making education equal to all, regardless of ability or original circumstance. Also employment, things like the Equal Pay Act, so that people are paid equally regardless of gender, although put a pin there for a minute, we'll come back to it. Civil Rights Act, based on race, sex, national origin, and the like. Age discrimination, pregnancy discrimination, American with Disabilities Act. You see a movement towards greater opportunity and greater protection, up through the Lilly Ledbetter Fair Pay Act. And I'll post a video about this, but the reason why 2009 we needed another Fair Pay Act, and actually there's one more that probably is really needed, is because employers found loopholes around the original Fair Pay Act. And so one person that was discriminated against and could not recover under that act was Lilly Ledbetter, and eventually a new law was passed in her name that allowed women to claim pay equity issues for much longer than they were originally allowed to. But this does not mean that we're done. There is still a movement to get an amendment into the Constitution that grants equal rights on the basis of sex or gender. That would be the Equal Rights Amendment. It has been proposed before, it has failed before. The Pregnancy Workers Fairness Act would treat pregnant workers as people with disabilities and protect them as such. They are not now because of the way the law is written. Maternity leave policies. Employment Non-Discrimination Act would protect workers on the basis of sexual orientation and gender identity, and so on. So you can see that there's a march towards greater civil rights, but it's a continuous march, and it does not begin and end with the things that happened last century.